Good evening or good afternoon, everyone. It's glad to be here. I would like to call to order our policy committee meeting on October 20th at 3:31 p.m. And so we have a couple of policies up to discuss, and we're excited to hear Chief Sivan sharing some of those updates, as well as our own Chief of Staff. I'm assuming, Christian, you'll be talking about the BLA and all of those other ones as well?
Yes.
Great. So in terms of order, do we want to start with Chief Sivan?
Sure. And I think Joe is going to put up the presentation. So this is another one of the policies that we started a couple months ago and then put on break for COVID-19, and we're restarting. And this has given our office a chance to dig in and really make sure that we were being as clear as possible about what we were trying to do here, and also taking the feedback from the first time around. So hopefully we're giving you a version 2.0. So this is a policy around legal representation, and it really is filling a gap in confirming what both the law is about when board members, employees, and volunteers are entitled to representation by Baltimore City Public Schools, and specifically by the Office of Legal Counsel or by conflict counsel. What's the process for that? And then also, in what circumstances does the system have an obligation under the law to pay for any judgment that may come in a legal case in the unfortunate event that that happens. So if we start out in the purpose section, we wanted to be clear here, and this is this entire policy is new, but this piece is particularly new for this version. Is we wanted to set out very clearly what the objectives are of the lawyers in my office and what the objectives are for a school system. And in particular, we wanted to tie our work directly to the goal of the school system to promote equity and academic excellence for all students. So our work is in service of the board's goals. And then also to set forth circumstances in which board members, board employees, and volunteers are eligible to obtain legal representation. So if we move on, we also talk about the responsibilities of our office, and you can go into detail. We just sort of set those out briefly. And then we also talked about the circumstances in which we get support from outside counsel, which are rare, but we just wanted to put that up. And in particular, if we go to the next slide, you see the factors that we consider in terms of supporting outside counsel in terms of quality of the work. And we added in there also commitment to equity in their own work, just like we do with other contractors as they move forward. And so then we turn to the next slide where we really get into the meat of this policy. And so the most important piece of this is the first sentence of this slide, which is our duty to provide legal representation to the board supersedes the duty to any individual board member, board employee, or board volunteer. So overall, we're providing support to the system as a whole. And so whenever a case comes in and an individual is named in that lawsuit, sometimes we have board members named, sometimes the CEO's named, sometimes individual employees are named. Our first step is to see if there are any conflicts, because again, our duty to the board is paramount, and then take steps to address those conflicts, including obtaining consent to the dual representation from the individuals, limiting the scope of the representation, or if we need to, retaining outside counsel for the individual. And flip to the next slide. And then the policy walks through and really summarizes in one place, because we don't want our board members or employees having to go to rooting through the statute. So really that first, in terms of board members, there's a statute about this, but the board provides legal representation for the defense of a board member who's involved in litigation because of the board member's service and in the board member's official capacity. That's nothing new, but this spells it out very clearly. Then the next slide talks about the standard for board employees, which we call board employees in this. And really, the standard is, and we've actually had this in a number of our cases, that we provide legal representation for the defense of a board member when it's a claim involving action that was taken by the board member in the performance of their duties within the scope of their employment and without malice. And that's critical because we don't represent if it's a employee doing something outside or doing something that was malicious to another individual. And we have to make that determination. And then finally, there's actually another statute, if you turn to the next slide, and we wanted to flag this. Actually, our BTU flagged this in the first time around, so we wanted to highlight this in the policy itself. There's also a statute that says that the board is required to provide legal representation when a board employee is involved in preventive action or intervention reasonably necessary to prevent violence on school premises, including intervening in a fight. Hopefully that never happens, but sometimes it does, and that statute provides that. And then finally, if you turn to the next slide, there are situations where even though we're not compelled by statute to provide it, at the discretion and in furtherance of our educational purposes, the board may provide legal representation if it's not covered or if it's determined later that it should have been covered. So that's legal representation. And then also we have a part of the policy, just to flip to the next slide, that clarifies that if board members, board employees, or board volunteers are witnesses or experts, we're also going to support them in that process. And that's important. Even we have a circumstance that we're dealing with this week where there's a contested custody proceeding between a family, and they've called a number of our school employees to testify. So we'll be there to support those people as they testify. It's interesting, we do lots of legal work in our office on all sorts of very complicated issues, but if you talk to principals and staff, they're often most concerned, as right they should be, about when they get a subpoena for records or to be a witness in a case. And we walk through a lot of work to do that. So we wanted to call attention to that. So if we turn to the next slide, so we've been dealing with representation. Now it comes to liability. So we vigorously defend the board, but sometimes, and we have a good record of success in our litigation, but sometimes we have to pay out judgments. And so we wanted to be very clear here to the community, what are the obligations under the law for payment of damages resulting from an action. And here you'll see the standard is that it's damages resulting from a tortious, first, this is, I'm getting ahead of myself. This is that the board shall be joined in as a party in a legal action. That's what this slide says. And then if you go to the next slide, I skipped ahead. A board employee first, acting within the scope of employment without malice and gross negligence, is not personally liable for damages from a tortious act or omission, except in situations which we go into in detail in the policy. And then a board member, it's very similar, acting within the scope of the board member's authority without malice and gross negligence is not personally liable. So that means that the district, the system pays for liability, not the individual. But again, it's important that it's within the scope of the authority without malice and gross negligence. So let's flip to the next slide. And this just talks about board volunteers. So a volunteer, there's also a standard that they're not personally liable in certain circumstances, again, unless it's malicious or reckless or grossly negligent. Let's flip to the next slide, just going forward. So the policy ends with a section on exclusions. So we don't provide representation or liability for actions beyond the scope of employment. We referenced that a bit. For actions initiated by board members or board employees, that means when a board member sues someone else. In internal proceedings, like when we're investigating an employee, and that this policy doesn't waive the immunities of the board under law. So that's the policy. The regulation then goes into the processes, if you turn to the next slide, for implementing this. It sets forth that our office is the conduit for representation requests, that on the next slide, that Our office is the only place authorized to accept service on behalf of the board, and that's very important because we don't want lawsuits going to individuals if they're suing the board. And that in the event that a board member, employee, or volunteer is contacted by a person attempting to serve a subpoena or a complaint against the board, they should be directed to our office and contact our office. Then if we flip to the next slide, it talks about the process for if a board member, board employee, or board volunteer receives a document directed to them individually relating to a city schools matter. The individual may accept service, but they also can have our office accept service, and that's often the easier thing to do because many people don't want a process server arriving at their home or at their school, so we do that for them. And that they shouldn't respond, we'll respond for them. Let's flip to the next slide. So then the regulation goes into the step-by-step for determining eligibility for legal representation. So when we get that notice, that complaint filed, we conduct an evaluation to determine eligibility. If we determine that someone's eligible for legal representation, we first look to see if there are any conflicts, and then we take steps to remedy that. The policy also talked about that. And then next slide goes on to the next step. If there is a conflict, we'll send out a reservation of rights letter, which is a fancy legal term for just saying that if we're agreeing to represent, the person agreeing to that representation as an individual needs to understand the terms under which that representation is provided. And then really clearly we spell out that even if we don't issue a reservation letter, we're going to work with the board member, employee, or volunteer who's named in the case for them to understand the case, understand their rights, and understand how it works. And that's really important because we want to really, while we deal with lots of litigation, most of our individual employees, if they have the misfortune to be sued, that's going to be the first time. So we want to walk them through that action. Turn to the next slide. This then goes into if you're not a defendant, but you want representation, we have a form that we created that will be attached to seek that, and we'll determine in a case-by-case manner if those would be services that we would provide based on our review of the statutes and this policy. And then I think we're, next slide. There are certain situations where we all determine that an employee is not eligible for legal representation. For instance, in a case where, and we've unfortunately had this cases, in a case where an employee has already been convicted of child abuse, we may decline that representation because that's outside of their, they're definitely acting outside of the scope of the employment by committing a crime. And so we'll notify them and give them the opportunity to object and have a process for that, so we're very clear that they have rights and they can appeal that if they want to. Next slide. Finally, we set out in the regulation that there's a duty of any board member, employee, or volunteer to cooperate with litigation, and just making sure that they're preserving all records that evolve the matter, and that they are promptly responding to engaging so that we can effectively serve them. Next slide. And then we'll talk about a compliance report. So just being very clear to the board. We already report to the board on litigation, but just being clear here about providing details on claims and representation on an annual basis. And I think that is the overview.
Great, thank you so much for that presentation. And are y'all hearing an echo? Let's see. Hello. Okay, so Martha or Commissioner, yeah. Questions for Chief Simmons?
Rana? Mind if I go ahead? Okay. So Chief Cities, given that the city-state partnership with Baltimore City Schools is a little different than other school districts, and that in a typical school district, the only employee of the board is the superintendent. But in this situation, because the chief legal officer and the superintendent are both board hires, how does this policy look different for Baltimore City than it might say in Baltimore County or Howard County based on the city-state partnership?
So I think that the important thing here is that the legal office is providing services for the whole system. And we made it very clear here that the duty to the board in litigation, because the board is, and this is similar to other school districts, the board is the entity that can sue and be sued. So that is the overall system structure. And so we walk that down from the board, and that being the duty that's paramount. In 97% of cases, there's no conflict between the board and the CEO or how this works. So, but we also set out the circumstances where, and you all have experienced this. There are some circumstances where we do represent the CEO, like in a quasi-judicial appeal to the board. And in that situation, if the board needs counsel to work it through, and sometimes it does, you all have Roger Thomas come in as outside counsel. So we spell that out in the policy as well here. But I think that the key point here that is emphasized, and I think you're right to emphasize this, is that the general litigation is going to be so-and-so versus the Baltimore City Board of School Commissioners, and that is the entity that we're defending.
Perfect, thank you so much. That's the only question I had on this one.
Commissioner McFadden, did you have any questions?
I'm good, Dr. Brooks. Just to Chief Seven and your team, thank you for putting it together. And I'm sure before it comes for first reader, if there's anything else or comments, Dr. Brooks, that I can think of or hear from, folks within the community, I'll make sure that you all get those.
Thank you. And I welcome, we did a lot of work to set this out clearly so that, and I think we'll also make sure that the clearer we can be to people engaged in these situations where they need to encounter our office and how this all works. So that was what our thinking was, even in setting this out and doing a new draft, so it walks through in a way that people can understand and be accessible. So any feedback about that along the way would be welcome.
I appreciate that. I personally think at the glance that we have right now, it's clear for me, generally speaking, with the Form 1, the request for legal representation, a question just as far as logistics is concerned, how will folks know how to access that in the event that they need to? Is it direct contact? Would it be a direct contact to the legal office? Or would they contact the board? How would that process work for them to take care of that form?
So we'll work to make sure it's available out there, but typically one of the things that we shifted a little bit is we didn't make the obligation to file a form for the sake of form. Sometimes we do that, but we said, so if you're named as a defendant, we're not going to make you go and fill out that form automatically, because in those situations, as long as somebody's getting the complaint to us, we'll work that through and work with them. The form really arises in two situations. One, if we're notifying somebody that we're declining their eligibility for services and they still want to contest it, they're going to fill out that form. And two, if they're filing suit themselves and they want us to support them, we want to fill out the form, because that's going to, again, be an unusual circumstance where they think that for some reason the system should stand behind them in an affirmative case as an individual, not the board suing, but an individual. So our hope, as we thought that through, was that there would be a very small universe of people who were acutely aware of the rights that they were trying to invoke who would need to use this form.
I appreciate that. Thank you.
Great. And I think one of my questions was similar to Commissioner McFadden, which was around sort of the availability of the form will be online in some way to be easily accessible. I appreciate that it's very clear that we support the district, and it is really good to know that that if under circumstances, I'm really glad that the BTU flagged that, yes, under intervening, in particular sort of acts of violence is also covered, because I do think that it's really, really important, and it does happen. And I also do know that sometimes it becomes a little balance between whether or not to intervene, and if you do, I know that some teachers, particularly last year when I forget which scenario that we got last year about a principal and it was some act of violence, but nonetheless, I think there's a way in which intervening in sort of, to prevent violence is sometimes left out, and it causes some teachers or staff people to not want to intervene. So I'm at least glad we can communicate that well. I think there were just a couple of things for me, particularly around, and I couldn't tell if it was just legalese in terms of at condition, like, it's conditional. So like, it's like, we will determine, whether or not we support you, if that's just kind of a case-by-case basis. And if so, then sort of, again, my question around equity, then how do we ensure that what's being denied one time is going to be consistent with the other? Or if it's just legalese, in which case, each case is so different that it's impossible to create a master frame to, if you will, to capture that.
So I think that's really important, and I think that I have a lifelong passion to minimize the legalese when we can. So definitely want that to be called out. But I think that these are really case specific. You're right, and I think that in the circumstances of representation, we just want to be careful that we're not representing two parties, that the board and an individual who then have a conflict later on. And what we'll do in that situation typically is to hire outside counsel to represent the individual. So we just, and I think that that's important because we're so they're not having to shell out of their pocket for legal, but we're making sure that we're guarding against that situation. And it may be that the conflict never comes up, but we've protected the board, we've protected the individual, and they still get their defense provided. And then on the liability front, and hopefully we don't have that many cases where we're actually dealing with judgments, but there the determination is going to be, was it, and it's a legal, there's a legal standard. Was it within the scope of employment? Was it malicious? And if the employee thinks that we should still cover the judgment, they're probably going to seek a court ruling on that too. So we'll have a judge following up on that. So case specific, but I think that we're really going here with what the legal standard is. And I think that, there are also some situations out there, and I've dealt with them in my time, where even if a court rules that something is grossly negligent, but it was a close case and we actually disagree with the ruling, we may support a principle nonetheless. And I may come to the board and say, we understand that we lost, but we think it's important for our principals to have a defense, and if they lose on a close case, even if we don't have to, but the board should still support our folks. And that may be a case-by-case situation, but that would be one where we would talk with and think about what is equitable in the end.
Yep. Great, thank you. Commissioner Hassan or Commissioner McFadden, any other questions? Great, thank you so much for this, and we're looking forward to seeing how this continues to grow and shape up as more and more feedback comes in.
Thank you so much.
Thank you. Who do we have next? The activity fund.
Well, good day, everyone.
Hi.
This is Courtney Desabay from the CFO office. I'm going to turn it over in a minute to Ms. Yvonne Walker, one of our budget analysts, who's going to be doing the presentation. Initially, this presentation was to be done by Deputy CFO Marianne Cox, but she was unavoidably detained today. So Ms. Walker has been gracious enough to fill in. She's been working with Deputy Cox on the process. And this is her first policy meeting, so go light on her. Anything we can't answer on the spot, of course, we'll take back questions and responses and bring them back to you. So I'm going to turn over to Ms. Walker now.
Good afternoon.
Good afternoon.
First time caller. Some of the background on the school activity fund is that we do rely on the Government Accounting Standards Board to outline how reporting is done, not only for the school activity fund, but also for the district. And the school activity fund is recorded on the books of city schools, and also it's subject to the same audit as city schools. And also the same audit that we take place for the district, we also do for the school activity fund. And hopefully the effective date for this will be postponed for 1 year. What we did to prepare for this and to determine what the issues are with our principals is that we conducted different focus group meetings with principals from high school and middle schools and elementary schools to see what was impeding their progress in getting this done on a timely basis. So issues were identified that impacted their semi-annual reporting and reconciliation.
Oh, you went on mute.
You got muted, Ms. Walker.
Sorry. Did you hear about the focus groups?
Yes.
Okay, so focus groups. Okay, so we use information from our focus group of principals and also feedback that we received from the internal audit department. Next slide. So some of the challenges that are faced by principals are related to the board policy is how to handle funds from vending machines designated for use by staff. And also we needed something in the policy to say that schools could create a separate accounting ledger for staff if they're using, if they're depositing their funds into the student activity fund, the school activity fund. The administrative regulations, which is the how-to, pose a lot of issues, and a lot of it had to do with how are disbursements to principals handled, because often they pay for things and then they're reimbursed. The resignature requirements for disbursements. We found that some schools had 2 signatures, some had 1. And also the process for avoiding checks. And also a big one is when schools close or schools change principals, what is the process for handing that off to the new person? And a lot of it was centered around training. Is there enough training? Next slide, please. So any proposed changes to the board administrative policies will affect how student activity funds are handled in the schools. Next slide. So the policy changes that we were looking at centered around definitions and also standards. So we updated the definitions for receipt summary, and also we added wording for the school activity fund definition to state that a separate general ledger could be set up for use by staff for funds that are deposited from vending machines that are located in the teacher lounges. What was happening before, all that money was lumped together, and they were keeping track on paper what was teachers and what was students. So we've added wording where they can set up a separate ledger in school activity fund to track the teacher funds separately. And also we added wording that required all expenses had to be paid by check with corresponding documentation, which is a biggie. Next slide. The administrative changes to how do we do things changes. Part 1, Section 1, number B, receipts. We clarified language on using pre-numbered receipts that are collected for monies collected by teachers and sponsors and advisors. And a lot of clarification was done on issuance of pre-numbered receipt books. It wasn't consistently being done in schools, the use of receipt books. We updated language for maintaining 3 copies of the receipts, and also added language for the receipt summary. We also discussed and made changes to update the process for safeguarding undeposited monies. Next slide. Also, we talked about how in the document, we added language to state the time frame for deposits under $250. And we also added language for the requirement of a validated deposit slip. A lot of language was updated in the documents to talk about the restricted use of undeposited collections. And we also updated the language on how to handle return checks. The language was not clear, so that's why we did a lot of clarification and updates to language. Next slide. Record keeping, there were just three changes in record keeping, and we added to clarify the procedure for reimbursements to principals, and we also added data fields for a check request form. And we're also requiring that all schools use a check voucher request form. And we updated documentation requirements for disbursements, and that's part of what the form will do. And also added language for the security and recording of checks. Record keeping, we added different types of bank accounts. Right now, we know that most schools just have a checking account, but a lot of large schools might have funds other types of accounts. We added language to verify ledger balances and safe books. And we clarified language on the principal's review of counsel checks and the bank statement. The word "and" is left out of there in number 3, and bank statements. Right now, what we have found, and as part of the focus group, is that they were looking at the bank statements, but they weren't always verifying the counsel checks. They were just going by the balances as opposed to doing a more thorough accounting for the counsel checks. We updated language to state the principal should sign and date the bank statement reconciliation. Right now, they were only doing it when they were submitting it twice a year. Now that we're changing how frequently it has to be done, they'll be doing it monthly. And we also update the language that for safe books, the reconciliation should be to the bank statement. Next slide. A biggie, school closure and change in principals. Right now, principals, if a school is closing, they will close the account and allocate money to the new schools based on where students are going. So we just updated the process for doing that. And also we clarified the language on the reconciliation and for the bank account and the safe book ledger when a school is closed or when a principal is changed. And also we added the process for principals to obtain access to the bank account, because sometimes they, when a principal changes out of school, and especially if the new principal has left the district, it's a little challenge getting the bank account changed over to the new principal. So we just clarified and cleared up that process to make it an easier transition. And for financial reporting, we added language to update safe books when a transaction is conducted. What we found during our focus group, that a lot of schools were not doing it on a monthly basis. They were not reconciling monthly. And we've added the language that when you do a transaction, you must update safe books. So you're not scrambling to get it all done when the reporting is required. And we also asking to change the reporting frequently. Right now it's semi-annual. We want the reconciliation submissions to finance, we want it quarterly. It also gives us an opportunity, if it's more frequent, to help them resolve any issues that they might have, as opposed to waiting 6 months to get it done. And also we added the language to add must for the number of years for record retention. So now they must retain records for 5 academic years. Next slide. Training was big. We do initial training, but we found that some principals need interim training or they need refresher courses. So basically we've added language to state how often we can do it, what type of training we can do, and also who can be trained. Right now it's principals, but since a lot of the duties sometimes for reconciliation or the reporting or the accounting part of it is left to AP or the secretary. So we're adding training for them also. And also When the audit is completed, an internal audit is completed, usually those changes or whatever the audit findings are discussed with the principal. And we've changed language to say that also the instructional leadership person and also the school manager can also be part of that review for the audit findings. Because we figure the more people involved, the more support the principal will have in meeting the challenges and correcting what's mentioned in an audit. And also, this is a biggie. Finance will add an FTE, a full-time employee who will be responsible for monitoring all school activity funds. So it'll be specifically just their job to do that one thing. Next slide. So next steps, here's just a calendar where we are with things right now with the policy committee, and we're scheduled for the first reading and the second reader. Next slide. And of course, when everything is finally approved by the board, we will notify the principal of the changes and give them an effective date to implement the changes. Thank you. Any questions?
Thank you so much for that presentation. Really, really helpful. Commissioner James, and do you have any questions?
Can I just add something?
Go ahead.
Yeah, and I assumed everybody knew what the school activity fund was. I'm gonna back up a little bit. The school activity fund are funds that are collected by students as fundraisers, also donations from other partners, all go into a fund that's specifically to be used for students' enrichment. It should not be used for anything that the district should be paying for, books, papers, pencils, paint, that kind of thing, strictly for student use.
Great, thank you.
Thank you.
So a couple of questions. So I'll start out with the student use. If say a student doesn't have shoes, it's at the principal's discretion to use those funds to allocate to student shoes. It's a student need. Is it very clearly specify that this is about, you contribute, $50 for a graduation party, that's the only thing it can be used for? Or what is principal discretion to move those funds or apply them to individual student needs?
What we have seen is that in the student activity fund, you can set up different accounts for different things. And if it has been an emergency need, funds have been used to buy a coat. I have seen that. If funds are allocated, say that the 6th grade collect money for their field trip, there's an account where it's just for 6th graders. It's all in the same fund, but there's a separate account for each activity.
So then to my next question, when I first came on the board, there was no common bank that the activity funds needed to be used in. So somewhere in PNC, somewhere in BBT, somewhere in Wells Fargo. Mm-hmm. And at one point we spoke with PNC, BB&T, and Harbor Bank about the option of creating a common account that's an activity funds account that BCPS has audit privileges over, but each individual signer in there is the individual principal that manages their own funds. Are we doing anything through this policy? We were told that when this policy came up, that is when we would look to systematizing this so that we have an umbrella sort of parent account. So all the funds are run through the same bank, so they can all then have the same accounting codes so that we can do a much more expeditious audit. Mm-hmm. To support principals, not to micromanage principals at all, mm-hmm. but to support principals, ensuring that they don't get too far down the road on something they can't back up on. Mm-hmm. That is going. So are we through one bank?
I am not familiar. I know all the schools have their own banks right now. Courtenay?
Yeah, let me chime in a little bit. So this is something that we have looked at. We started with, like you said, PNC and also M&T, which is, handles a lot of our banking internally in finance. And one of the major roadblocks that we've run into is that there's a need for physical access to locations that make it a little prohibitive for us to go with one specific bank. So there's schools that are close to or within walking distance of one particular bank, but that's not the same for every other bank or branch. So we're looking at ways around that. And, as we transition more to an online banking platform and, taking pictures of checks for deposit and so on, we're getting a little bit more leeway with that. But we have reached out to a number of our banking partners with regards to this. And we still think it's a good idea in terms of being able to have the direct oversight and unified view of the accounts. But it's not 100% there yet.
But so thank you, Courtney, for that. Given that we can now do things like photo depositing of checks, I think that this makes this a ripe time to institutionalize that practice. Again, as a way of helping protect principals and schools. I would also ask us to reach out to Harbor Bank as a Black-owned bank and Black-run institution in this city. I know that I have talked to leadership there, and they are definitely willing to work with us in helping us make sure this can happen, as well as spend our money in the way that aligns with our mission and vision. So along those lines, then, just two other pieces. And just to be really clear, until we can do this as a systematized thing, it's going to be a challenge for me to vote for the policy, because I think this is the time where we can really institutionalize this and help protect against some of the things that have happened in the past that I don't know are necessarily ill-intended, but we certainly have gotten negative bad press, and we still have a number of our former staff members who are in prison over this. So being sure that we are protecting and guiding appropriately. One would be just a crosswalk on the policy regulations with the vending machines to remind people that wellness policy requirements for what is in those vending machines. So another crosswalk with another policy. And then around the area of activity funds in general and what they support, and what is the policy if a student cannot afford? So if a student can't afford to participate in an event because they can't afford the activity fee, what do we have in policy to ensure that all students have access to the events and experiences sponsored by activity funds?
Can you expand on that one a little bit? Are you suggesting that we include something in the policy to address that specifically, or is it, something that you want us to kind of do some research and get back to you on? Just understanding the question.
Yeah, so I appreciate that. I would say that it's just, as we look at an equity lens and as we look at who's included and who's excluded, the idea that we have a requirement of you must come up with $200 in order to participate in a graduation party or in order to go to prom, that's exclusionary for many of our students. So in the foundational just premise of having an activity fund, we know we need those supplementary funds. We know that parents and families should contribute in order to participate. But if a student cannot, at this point, I know for fact in several schools, principals have simply told students, well, if you can't pay, you can't go. So how do we as a board institute an institutional policy saying, which would also be much easier if it was an umbrella bank account, and we could do sort of a 10% across the top sort of sluff fund to support things. How are we ensuring that the really rich and enriching activities that activity funds support are not only available to those students who can afford $200 or $50 or things that become fairly substantial amounts of money at some points?
Okay. I think I understand better what you're saying. And do you think this is something, my initial thinking, I don't know if this is something that is part of this policy. Is this something that you think should be, or is this something that we would handle under a larger umbrella of an equity discussion?
I think it's a both end, actually. I think it's something for this committee to consider and to think about. I think it's something for all of us to be on the same page about, sort of imagining a space that's more equitable in the rich, beautiful things that come into our students' lives. And being able, through the policy, to provide guidance to principals in how to handle that and how to address it, especially if activity funds are coming from students. So everybody puts their $200 in for prom, and then if principals have discretion to take money out for coats, for shoes, for meals, for in the past buying gaming systems and things like that, how are we ensuring that rather, that we're just being considerate and conscientious about both the purpose of activity funds, which is to provide extended opportunities, as well as the basic foundational needs and ensuring that we can meet students' needs around things like coats and meals.
Okay.
And if that's fuzzy and they can go back and forth, I just think that opens us up to, it becomes a slippery slope with where's that line.
Okay.
That's all of my questions, Mr. Chair.
Thank you, Commissioner James. Commissioner McFadden, you have any questions?
Thank you. I'm curious to kind of align with Dr. James's point with the discretionary funds. Should we be including in the regulation, in the regulation perhaps, language about principals' use of discretionary funds, when they can be moved, when there would be an opportunity for them to use it for specific things, similarly to what Dr. James was discussing. If there's a student that, is without or is unable, is a principal able to shift? Should we specify that in the regulation?
I think that's a valid question. To Commissioner Hassan's in the earlier statement, I think it's something we should definitely look at. It is an area that is somewhat ambiguous right now, but I think you're right that we would benefit from it being a little more transparent. My only concern is sometimes, putting that out there offers uses that may not necessarily be considered or may, prompt situations that might otherwise, be avoided, but it's probably better to be explicit with those, which I think is what you're pointing out, and I would agree.
I appreciate that, Courtenay. I think we should be as clear as possible in this regard for that. So I will be eager in seeing something like that during first reader in the policy. Also, I'm glad that Ms. Walker, that you mentioned the training, because that was a question that I just had previously. And often with policies, when is it appropriate in a regulation to specify when certain trainings happen and occur? And so I appreciate the clarity in the regulation for when the training happens and the ongoing training that is offered. I appreciate that. However, I did not see a place for compliance report on this in the actual policy or in the regulation. So are we not considering some sort of reporting annually to the board as far as where we are with this policy? And this is actually to my colleagues. I'm just thinking, like, what would we want to receive an update on in regards to this particular policy? Because there is no, unless I missed it, there is no place for a compliance report to come to the board. Did I miss it, or is it not there?
No, I believe your observation is accurate. The general reporting is part of the regular audit, but I believe your observation is accurate. So is the request that we do make a regular, annual, or whatever periodic report to the board on compliance with the policy?
I would like to see that, but I'm curious to know what my colleagues would think. Specifically, what would be the types of things to come back? I understand what you're saying with the audit, but I'm wondering what would be reported on. That's just what I'm trying to wrap my brain around.
So if I can offer Commissioner McFadden, one of the things that I think might be really helpful for us in a reporting criteria would be the remaining fund balance at the end of the year, as well as the ask for students. Because what we might want to do when we start doing equity-based budgeting is look at those activity funds, and if we see school A has $100,000 carryover, school B has 0, we know school A has the opportunity to provide so many more rich experiences for young people that we might want to do some, like a small school supplement to enhance that.
So a balance could be something that is reported on annually.
Even like, you know, and on that balance sheet, what were their quarterly balances throughout the year? So we see how it grows and how it's spent down. And if there's a large fund balance, then we might want to talk about some interventions for that principal in how you're not using your funds that those students offered for those students' experiences. Or is there a point where they want to create a slush fund, and is it 10% of their activity budget or whatever? So I think there's a number of really important metrics that could come back that would do a similar thing to helping support the equity of distribution of funds, as well as collecting funds, and then help, again, protect principals from ending up with, you know, a $250,000 carryover. So they start, you know, doing things that are not necessarily ethical, legal, or moral.
That's an interesting thought. I also think about training being in the compliance report, which principals participated in it, when they did, if they needed a refresher. I think that could be in something important to include in a compliance report, where we can see and consider accountability measures. You know, as far as the student activity funds are concerned. Dr. Brooks, I think you were about to say something.
No, I was going to jump in and just offer, you know, I think as you were saying, Commissioner McFadden, like a part of me, and I'm thinking out loud too, so like there are some really specific pieces around monitoring in terms of the policy that I think would be important. And so in addition to sort of which schools, which staff, how many, like, so if folks are schools actually utilizing the training, you know, sort of like who's being a part of that, so that we can track and monitor the fidelity of the policy. And I'm just thinking out loud, I'm not necessarily sure about sort of the funds, like, and sort of, I'm trying to figure out, either do we want to, like, what does the audit report sort of capture and what data is there versus sort of what we would need to see here? Do we need to have a joint conversation with, you know, audit to figure out whether or not we need an additional policy, or do we say there's something in auditing that we want to see already to just to us in terms of tracking and monitoring? So I think that is a possibility. One of my hesitancies around one of the pieces that you shared, Commissioner Hassan, was particularly around determining which, if a school has a large sum of student activity funds, and then sort of redistributing it over to a school that might not have any. So I'm just not sure what the implications of that are. And, you know, I think as a committee, we could explore collectively what that might look like. And I also know my initial hesitancy to be saying, like, I think some folks might be a little alarmed and lost.
Yeah, clarify.
Yeah, I didn't think, I thought you were saying.
That wasn't what I was saying at all. And let me just, I wasn't saying redistributing, but I was saying that, so we have a small schools allocation that we give to support small school budgets. So my anticipation or guess is that we've got some high schools that might collect, you know, $10,000 a year, and some high schools that are collecting $200,000 a year. How do we as a board ensure that the experience that each student gets is similar, as far as post-prom parties, post-graduation parties, homecomings, things like that? So it might be a budget out of our general funds that we need to allocate to schools that aren't able to collect the revenue that other schools can. So I'm not talking about taking like money from city and giving it connections.
Sure, but if we see a trend, right, over
thank you.
time.
So
sure,
thank you
I
for that.
understand that. Yep.
Okay. Let me add to that, though. We will want to be kind of cautious in terms of how we interpret that data. There are a number of factors that could lead into that. You know, the efficacy on specific school leaders, their ability to do fundraisers, or different, you know, the neighborhoods and income in those neighborhoods, and what people have in terms of disposable income to contribute. Or, you know, there are a lot of other factors that I would hope we don't read too much into, you know, the outcome of the numbers based on some of those other factors. And also just remembering, the use of the funds is very distinct from, our fair student funding dollars, like you said, the baseline supplemental funding and what we use it for. So making sure that those things don't overlap as well. And I would be cautious of, and while I agree with the intent of your proposal, I would be cautious of a scenario in which we then take fair student funding dollars to supplement something that is already supplementary, if you understand what I'm saying. So I would, be very cautious about that. But I do understand the intent behind what you're saying. I just think we have to be careful with the data. And to one of the earlier points, from what we're describing in terms of the compliance report, at least to me on the onset, sounds like a lot of information. Like when we're looking at the account information by schools and the periodic and how they've been over time or quarterly, and that sounds like a lot of data for you, which, if that's what you want, it's fine. But, we might want to think about how we want to distill that, or if we're breaking it down to 2 or 3 key points or metrics or tracking items that we want to use over a period of time, as opposed to that larger data dump.
Yeah, can I just add to that, Courtney, because I agree with you. I think we've been trying to think really carefully about the compliance reports across policies, because most policies have compliance reports, and it ends up being a lot of compliance reports. So I think, we've experienced definitely sometimes feedback from the board that some of the compliance reports are kind of perfunctory. And I think they become perfunctory when at this point, I think we have 80 plus policies, most of which have a compliance report that's an annual report. So you're talking about multiple compliance reports a month that we're putting together. And so it's hard to do them deeply when there's that when the volume is that. So what we're trying to think about is how to align them so that you're getting the information that you need, because if there's a policy that lends itself to a compliance report, I will say this is one. So it makes sense for there to be a compliance function. It's just we have to figure out how to fit it in with to the point that was raised about what audits are already occurring. So how do we utilize what the functions the control mechanisms that are already in place to monitor this? And then how do we add kind of the additional layer or fit it in with other policies, other financial policies, so that it could be put together with other reporting requirements that are already out there for other policies. So that's what we're trying to think about, is how to not just to have 1,000 flowers of compliance reports that are all kind of separate and aren't giving you a comprehensive picture, but how do we make them comprehensive and actually use them? So we can collect endless pieces of data. It will take us away from other work, frankly. And so what are the key pieces of data that you need that's not just filling up your inboxes with data that's too much for you to really make sense of, but what are the key metrics that you need to see in order to see that we are addressing the concerns that Commissioner James is rightfully raising about the past of this, that we are actually putting controls in place and training mechanisms that we're really honing in on kind of the repeat findings that we see. And that's one thing we've really learned from looking at this, is that when you look at our internal audits, it's kind of like the same kind of areas that we see problems. We need to hone in on training in those areas, that we're honing in on training for new principals, and that we're honing in on any trainings if there's any repeat schools that have had this issue before. So how do we give you that information that's really usable and really is demonstrative of a systemic and to implement this with fidelity? And I would offer that we come back to you with some ideas about that.
That was going to be my follow-up and request, because I do appreciate Dr. Brooks's thought about making sure that we're cross-referencing, particularly with audit, right? Internal audit, and seeing what is happening there. But certainly with our fiduciary responsibility as board members and student activity funds looking to be, an issue inconsistently, I think it is critically important for us to be aware of what is happening, and for us to kind of, be able to support schools and communities to do a better job with accounting and making sure that we're appropriating funds correctly. So I appreciate that. Dr. Brooks, I just have 2 more things, if that's okay. The additional accounts that schools are able to maintain, or organizations, for example, like a PTA or some sort of booster, they're able to hold money in other accounts. Ms. Walker, are you shaking your head? Am I wrong?
No, the only funds that are in the student activity funds are specifically that are raised by the school itself or by student fundraisers. and also funds that we receive from Pepsi for the vending machines in the teacher lounges, because there are no more vending machines for students. There are only vending machines in the teacher lounge. So when they get that little check for $16 the first quarter of the year, they have a separate fund within SafeBooks where they're tracking what the teachers receive. That's it.
Completely understand.
But no PTA funds, no Booster Club funds are in SafeBooks.
We don't monitor those.
No.
Okay, I just wanted to
Well, we don't monitor them in SafeBooks. I don't know how they are monitored with the PTA or those other organizations.
But if a PTA has a separate account where they're raising money to support a school, that isn't something that we are monitoring, correct?
We are.
They're able to utilize that money however they choose to raise it and spend it. Is that the understanding or no?
That is correct. We don't have insight into any accounts that are not either in SafeBook or explicitly city schools accounts. So any account can be created for any purpose that we have no way of knowing or tracking or having any insight into for some of those.
That's what I wanted to know. Thank you. And I know that policy KCD is also referencing this in regards to donations and how reporting for donations is handled also. So I appreciate that cross-reference. And to Dr. James's point with the wellness policy, it would be nice to see that since we do reference the vending machines in here, if we would be able to reference that. And I think that might be it. No, two additional things. With the feedback though, about the policy, I would love to hear what principals are thinking in regards to this policy and the revisions. So hopefully that will be included first reader, because they are critically important in how this policy comes to life. And it would be great to just get their perspective in a cohesive way where we can also support in the development and crafting of this policy. I just want to make that note. And then finally, Dr. Brooks, I know that the implementation of this policy, Ms. Walker, you referenced earlier, will be postponed for a year, correct?
That was a note that Mary Ann Cox made, so I'm assuming that's correct. I would have to check with her.
Yes, ma'am. It's no worry. My concern is there something in the policy that could speak to remote working and operating? If that is appropriate to place in a policy like this, for example, if donations are received somehow and, people have to make deposits of some sort, and if we're remote, I know that Ms. Courtney was mentioning, online banking and us evolving and moving into the 21st century. But would it be appropriate, and this is an honest question, so would it be appropriate for us to consider a remote addition to the policy, given where we are and given the future?
If I may, that was something that kind of crossed our minds more recently. There was nothing that we could see explicitly in the language of the policy that excluded that or prohibited that in any way. I mean, the only thing that stuck out was the writing of checks in some instances, or that being a physical activity, and that's something that we'd have to consider. But there's a certain accountability that's associated with that as well. But there's nothing in the policy really that prohibits or is particularly restricted by our current mobile environment. So to answer the question, we didn't think there was any need to explicitly state it. Yeah.
Okay, thank you.
Yeah, and I would just add, and I think maybe just for the sake of being explicit, there might be some need for some language around that and some more guidance, even if it is this process is similar into particularly around tracking, right? So if you got for example, 3 receipts, right? So in that situation, you're not going to have 3 receipts. Are you just telling people to just make a copy? I mean, a screenshot of their deposit and then have that as a backup record or whatever. So, I mean, I think there are ways in which you could write some guidance in there around that. and I just also had a random, I was like, are 3 receipts available to everybody? I was like, okay. So the 3-layer paper. So yeah, so just things like that. And was wondering, in a more serious note, if are they standardized? Does Central ensure that each school have access to those to actually do their job? And then if so, one, hopefully that's great. And then to make sure that folks don't have that as a reason not to be able to meet the policy effectively. So that was kind of just one thing that I had. I also thought about, I know there was specific, like you're only supposed to, get, cash or checks, but then I was thinking about Venmo, right? So we're in the age of Cash App, Venmo, and so forth. Do we want to have language specifically in there? And then sort of what does that process look like for us? Or whether it's like, no, don't use it, or yes, we permit it, and then therefore let's talk about, X, Y, and Z additions to the policy. And then the training modules, I thought that was great add. I was also trying to figure out, or maybe the question was, are those virtual just learning modules that people can take? And if there were assessments at the end of that was it more like a checkbox that says you've done this, or was it like also some way to assess for skills development to make sure that people were actually able, they have retained the information enough to actually do their jobs effectively?
Because of the virus, we have been doing finance. They were giving all the training materials to the principals to walk through, and once they completed it, that they were given access to safe books. But we do not have online training modules. Okay,
so these are old. This is traditional, not old school.
Tradition, yes, it's traditional training and traditional in-person. Yes. Yeah.
Okay, I guess my rec would be that if it's possible, and I know that a part of the, the learning and development, office, I believe is really about trying to modernize, and I think that also might be attached to the new system that we got for tracking and monitoring. But if any way that you could sort of make those sessions available, virtual or asynchronistic, I think that would actually be great, given that we're in this new environment. And then it would allow principals, and I think it would minimize people's, it would give people greater access and opportunity to do it at their own space instead of these having to schedule out and things like that. You could just be following up in those paces. And I think that was all that I have on my notes that that have not been addressed. And I just had a note of concern, which was just around principals, and then making sure that they feel capable in order to if they're going to be the persons responsible for ensuring the fidelity of this, that they feel supported, they feel safe, and encouraged to actually do it and to do it well, given that there's so much that they have oversight over that particular area. So
I think that's a good flag, and that's why we've really included the school managers in this as we've really focused on how to redo this. And what we're realizing is that from the training perspective, and just from Commissioner McFadden's point about engaging principals to get their input, because they are the ones who have to live with this. So we need to understand what the barriers are for them. And so that's why we've really worked closely with them. But I agree, we have to keep making sure that we're listening to them about how to effectively engage them around this, because it is a big responsibility, and it is not their primary responsibility. Their primary responsibility is to teach students. And so we need to figure out how to facilitate their ability to really focus on instruction and have the skills necessary to be able to do this well, so they don't get caught up in this. And so that's a delicate balance. One last thing I think is important to note is that we also have worked closely with the internal audit office on this. So they have reviewed the policy and given input on the policy, and a lot of the rethinking of the policy is reflecting of work we did with the audit committee and with the review of past audits to really learn from, again, like when you look at the school audits, there are some kind of regular things that trip people up that we really tried to figure out how to support them here, because we've got a lot of good principals who, when you take over a school, you're thinking you're doing instruction, but you're really running like a mini city. You've got personnel issues, you've got transportation issues, you've got health issues, you've got finance issues, and that's a lot. And so how do we facilitate? I mean, we may have a great instructional leader who this isn't their strong suit, and we want to make sure that we're giving them the support to be successful in this area so that we can facilitate success in the area that is really the primary focus, which is instruction for students.
Great, thank you. And I see 2 hands. I just can't remember which order. So Commissioner McFadden or Commissioner Hassan.
I just want to, reiterate, hearing from principals is that's important. City schools principals, they have to have a very special skill set, right, in order to do their jobs well. And so I think it will be extremely beneficial for us to hear from them. I'm also curious to hear about training for ILEDs as well, and how ILEDs are able to support and the networks are able to support principals based on our system structure, and making sure that these school activity funds are handled and accounted for in a cohesive way. So that's something, Courtney, I don't know if you're unmuted still to talk about that. I don't prefer an answer immediately about it, but it's just a flag that I just had the thought of when Allison, when you were talking, and when Dr. Brooks was talking also, right? Where is the level of care and support and developing of our school principals, and making sure that this is done in a way that is, it's important, but we also, to Dr. Brooks's point, have a responsibility to educate and take care of our children. That should be the primary focus of our young people. So that's all.
Yeah, no, I think that's very pertinent. And as you know, we've discussed this a number of times with the budget process as well. Like, we know that's not the primary, objective. It's the education portion of it. But knowing that, we try to provide as much support as we can. Just like, we do the collaboratives and stuff for the budget, and we make sure that all the central office staff are involved and all the rest of that. So I think the approach will be the same here, is to try to blanket principals as much as possible with support and training on this issue. And I think you guys have provided some very valuable feedback in that respect. ILEDs are more of a constant than principals because of turnover. So as much as we can do with training and support on their end as well, I think is extremely valuable too. So this has all been, terrific feedback in terms of the policy so far. I appreciate it.
Thank you. Commissioner
Deputy Cox does as well.
Thank you. So I was actually going to mention ILEDs as well, because the principals, even those that ended up facing, judicial consequences and incarcerated consequences for this, the ones that I talked to, most of them did not fall into it with any intentionality. Just it snowballs, and a kid needs something and a kid needs something, and you find it. So what I was going to bring up also was the idea of the ILEDs, and perhaps even institutionalizing that in the regulations, that an ILED has a fiduciary responsibility over supporting the principal. Very, very few principals go into school leadership because they're accountants. They go in because they're academics, or they believe in children. And the financial and budgeting and accounting things are added on duties. So how are we providing that operational support to ensure, if we're not doing an umbrella account where we can do a snapshot at any moment, how are we ensuring the ILEDs are providing that fiduciary oversight and support for the principals on a daily?
So we should think about that. We really have we focused more with the school managers as the training and the support arm of this, because they do the more operational side of schools, while the ILEDs often are more the instructional arm. They supervise the principal, but a lot of it is more the academic side of it. And so the school managers are often more the operational side. We can think about if there's something we can put in there. I really don't want to take ILED's eyes off, that other key part of the work, but is there a way that we could, I don't know, think about how we make sure that audit report, like we do already, there is a sign-off process really with school managers for the audits, but we'll just think through how to make sure that it's like if there's key issues in a school that that we make sure their supervisors are aware without at the same time making it such an onus on them that it's really not, it's taking them away from their key work at the 13 schools that they oversee. So.
Yeah, I see that, Allison. I'm just wondering if, and maybe it's just a lack of knowledge on my part as a board member about the role of the school manager.
Yeah.
But are they there, sort of, I see the ILEDs as the kind of weekly, monthly touch. So they're there. And if school managers are there in that same role, then that could totally be
they're
the
in
space
the
that houses.
Yeah, there for each ILED there is a manager, and then there are the more operational side. So they are really in the schools.
That's a failure on my part to understand.
Yeah. So they are. That's what we thought was the more natural link, because they do provide that kind of support about how how the school is running, kind of, and they're vital to schools. I mean, schools will tell you their school managers are really critical. So I think that's where we focused it more.
So do the school managers have an administrative license? So they've had the school finance classes and school law classes, so they understand the repercussions of errors in these areas?
I don't know if that's a requirement for being a school manager or not. I think a number of them are former principals, but it's not necessarily that all of them are. But I think
if they're not, that might be a professional development that we have to make up that gap so they understand what they're seeing. Thank you. Thank you, Mr. Chair.
Great, thank you so much for the presentation, and we're looking forward to seeing more of it. Ms. Walker, thank you so much for the presentation, and it was good to see some new folks in the space as well. So thank you. And I think on that note, we'll end with our own Chief of Staff, Christian. And as we explore the additional policies, BLA, BLB, BLC.
Good afternoon, commissioners. Give me 1 second. Let me get my slideshow together. Okay, can everybody see my slides?
Yes.
Okay, thank you. Good afternoon, members of the policy committee. Today I'll be presenting on revisions to policies BLA, BLB, and BLC, procedures and appeals and hearings. First, as a little background for members of the public who may not be familiar with appeals and hearings, Maryland law gives employees and families the right to appeal final decisions by the CEO or CEO designee to the board. Policy BLA coincides with the Education Article, Annotated Code of Maryland, Section 4205. And again, those are final actions of the CEO, such as contract non-renewals, bid protest, or evaluations, for example. Policy BLB is reserved for the suspension or dismissal of certificated employees only. But as I'll explain, BLB is a hearing, but not an appeal, because the board actually has the final decision, or the decision as to whether the employee will be suspended or dismissed. And finally, policy BLC is reserved for students, and that's specifically students' rights to appeal an extended suspension or expulsion of 11 days or more. So this policy revision was in response to an appellant's request to withdraw their appeal after a hearing examiner recommendation was issued. And again, for members of the public who may not know, typically the board employs hearing examiners who either do an appeal on the record or an evidentiary hearing to kind of take a look at the record and provide a recommendation to the board. So in this case, the appellant attempted to withdraw. The board decided to deny that request, and there was a request to have the policy amended to reflect that decision. So appeals and hearings are typically heard in 3 different ways. There's appeals on the records, which we've kind of in the office called paper appeals, but as part of this decided to formally define. In that case, with the appeals on the record, there is no hearing. However, both parties are able to submit evidence for the hearing examiner to consider. So everything's kind of done through, through submissions and records. These are they're evidentiary appeals, which are kind of like you would think of a trial where there's witnesses, there's live testimony, and again, the hearing examiner uses that to come up with the recommendation. And then oral arguments, which I will get into more detail later, but these are spoken presentations about the board on specific issues. So for the appellant case withdrawal procedure, we added that to all 3 policies. For appeals on the record, we settled on 10 days after the CEO response is sent. The reasoning for that is at the end of 10 days, an appellant will have an opportunity either to proceed with the case or withdraw, but it'll prevent the wasted resources or money of having the hearing examiner start taking a look at the case and coming up with the recommendation. So again, after 10 days after the CEO's response is sent to the appellant, they have a choice as to whether to proceed or withdraw. And for evidentiary hearings and oral argument, it's 5 days before the hearing. And again, the rationale for this is, to prevent the waste of resources or money for the system and, have that withdrawal happen before the hearing. The virtual hearing, legal also suggested some provisions that we've included in here. One was just virtual provision on virtual hearings, allowing us to conduct our hearings virtually. And then going back to the oral argument provision, we had a pretty healthy dialogue about changing the definition. The previous definition was very close to the definition of evidentiary hearings, but the new one is pretty in line with other counties. So what this does is, again, an oral argument is intended and in closer to like an appellate court. So if your evidentiary hearing is kind of like a trial court where there's evidence and witnesses, the oral argument is more similar to just you're talking about matters of law or policy, just bigger issues. So that's going to be what an oral argument will look like. However, Section 6202 of the annotated code does give the county board the right to directly hear proceedings if they choose. So to preserve that right, in the policy, there's a proposal to have a panel of 3 board members holding an evidentiary hearing as a hearing examiner would do if the board chooses to do that. So that does preserve the board's right if they choose to hold a hearing. And then again, those 3 board members would issue a recommendation that the full board would then decide on. So moving on to just policy-specific revisions that are in these set of revisions. Again, adding a definition for what an appeal on the record is. In previous versions, it was kind of alluded to, but we want to be very clear about what that is, and especially because we needed to define the time period, so it was necessary to include that definition. BLB, I kind of alluded to this earlier, but there's a removal of references to an appeal because it's technically not an appeal and that the CEO cannot suspend or dismiss an employee, only the board can. So when you do receive BLB appeals, the board, there's a hearing, and again, it's sent to a hearing examiner like normal, or the board can decide to directly hear it, but it's not an appeal. It's, kind of like the first impression, the board can decide if they're going to approve the recommendation of the CEO to suspend or dismiss the employee. We also included language about arbitration. That was something that was in Maryland law, and now it's being reflected in the policy. Currently under policy BLB, an employee has a right to take the route of an appeal through the board, or they can request an arbitration in which the board office assists in choosing an arbiter that will hold holds arbitration sessions for the 2 parties, and that arbiter's ruling is binding on both parties. And finally, in policy BLC, there was a provision on the CEO administering oaths in a hearing. And this was originally sparked because I found like there was a gendered reference where it said he, and then that kind of led to me taking a further look. And Section 4205 of the annotated code does say the CEO may administer oaths, but there's no reference to unless he is a party to the proceedings, which was in the previous version of the policy. So that was removed. And now it just says the CEO may administer oaths in when there's a hearing. And finally, policy outreach. We sent these. This is all the groups that we reached out to for feedback on the policy. We sent that email on October 14th, so that was last week, and we reminded them that per the policy, there's a 30-day period between now and 30 days to provide feedback. So this is every group that we reached out to for feedback on the policy. And that's the end of my presentation. And are there any questions? I'm going to end this. I'm going to stop sharing. Okay.
You're muted, Ronald.
Oh, thank you. He was pointing to me. Yeah. And thank you so much, Christian, for the presentation. Do we have questions, Commissioner Sun and Commissioner McFadden?
I'm just glad that the revisions were made. Well, the recommendations for revisions have been made. I'm just glad that they've been made. That's all.
So, thank you. My question is more about process. So thank you also. The revisions are important. Is it possible we could set up like a workflow where, you know, in my other job, you know, if I have a appeal on a grade, the student puts in, fills out the form, it automatically then triggers certain events to link. That the student gets a constant email back on your appeal is now with the chair. You have 20 days to respond. So that every linchpin along the line, every link along the line is included in sort of a cascade of cause and effect. So someone puts forth an appeal, it's going to go to the board office. It needs to be assigned to a hearing officer. Then that person gets an automatic reply back. It's been assigned to a hearing officer. You will hear back in 20 days. You have 10 days after that to respond. So that it's an automatic system. And I feel like this is one of the big buckets, along with many things in HR about appeals, that would be really nice to have an automatic system in place where there's a cascading effect of, I put in this document, here it goes out to these 4 people, I get a response back, it's gotten to those 4 people, I know the timeline, I know my parameters to respond or not respond, because while all of it is great due process, and there's also some special ed spaces for this, all of it is great due process, but people get lost in the dates and they get lost in the tracking. And that automatic system could then bump them a weekly email. Remember, now you only have 10 days to respond. Now you have 5 days to respond. And it's arduous work for any human to track, but I feel like there's got to be enough apps and things out there right now that if we could start automating some of these pieces and putting them into automatically cascading workflows, might be beneficial in both supporting everyone being, you know, complying to due process, as well as being able to hear the needs of folks and respond in a time appropriate manner.
Thank you for that, Commissioner James. I would say, well, first, we are bound by the timelines. The board office is bound by the timelines in the policy. So, you know, for instance, there's a lot of places where it says the board executive officer shall send in such days or X days. Also, we kind of do, currently a lot of that work is done by Tanisha. And I think she's very efficient at keeping track of the timelines, et cetera, reminding people. And additionally, too, we do have some flexibility. We understand that we're dealing with, you know, some people that are unrepresented, some people that are teachers. And that's why there's a provision in the policy that allows some flexibility for timeline. You know, if you miss a timeline, I have the right to extend deadlines, et cetera. So I would say we're pretty lenient about that. You know, if a person has a compelling reason why they missed a deadline or et cetera, you know, we give everyone a fair hearing on that. We could perhaps look into maybe work with IT to see if there are some kind of automated, you know, some kind of automated systems. But as it stands, again, Tanisha does the bulk of that work of adhering to the timelines and making sure that, you know, we are in compliance with the policy.
And Tanisha's amazing and does a phenomenal job of this. So it's not a critique on her at all. I'm just wondering if there's not an automated system that would make her life easier.
Mm-hmm.
And there's a number of things within city schools that this sort of action A triggers response B,
Mm-hmm.
whether it's in due process for special ed, whether it's in hiring, whether it's in, an appeal, whether it's in curriculum adoption even, that having a workflow system where action A is going to initiate a cascade of responses that have to go out to X number of people would help systematize things and help us avoid some hearings and help empower people to understand, oh, you submitted this report on, on a sexual harassment thing. Then boom, these are the emails that get triggered from there. And this is the timeline that gets sent to people. So they get periodic reminders. I think it's something worth looking into. Whether directly connected to this particular, policy or in general as a way of doing business would be worth looking into.
Thank you.
Christian, from me, I just, my question was more around ease, specifically around students, accessing this. I don't know if I've actually seen any students appeal in the process. So do we have any data on when students make go through this process? And if so, do they have a sense of whether it's easy or not for them to do that? Or do we have any supports for them?
Dr. Brooks, before you answer, Christian, Dr. Brooks, I'm curious to just open up to my colleagues. When would be an opportunity for a student to appeal? What would a student appeal? Would they be appealing an expulsion or a suspension? Would those generally be the only two things that a student would be appealing, or perhaps their family?
Definitely the suspensions and expulsions. We've also seen typically pre-K decisions are typically appealed by the parents. So those
and
are.
I would say the other big bucket is who gets admitted to high schools.
Right.
Well, yeah, I haven't seen many of those, but those could definitely potentially be a BLA appeal.
Great. And so I just haven't seen any of them, and I just was wondering if we were tracking that. And if so, I would love to just get a handle on, just to figure out what that process is, especially because I know at the suspension side now, we should, now that the state had passed their policy, no more suspensions for, I believe it was K through 3, there were no more suspensions there. But if they're for the older students in the high school age, or if it's easy for their families to do that process as well. And that would be helpful to know. And Christian, the only thing I would was also on my mind when I was reading this was, do we know how the process is working for people, right? And so going back to Commissioner Hassan's point, is it a cumbersome process? For whom? Is it pretty straightforward? Particularly if we want students to be able to use this and is it easily identifiable as a process and so forth? So just things like that came up as I was looking at it.
So in response to your first question, we can provide you with the last 3 fiscal years compliance reports, and those include data on our student appeals. Regarding the second part, I haven't gotten much anecdotal data about the difficulty or such of the process. I would say when there was, I'm not sure if you were on the board yet, there was a revision round last year, and we did hear a lot from a lot of our advocates, especially the ones that represent students, ways to improve the process, which we did. So outside of that, I haven't heard much feedback about the difficulty or such of the process. Like I said, I do say, and I'm slightly laughing because I think the board office were pretty, we try to be as friendly and helpful as possible to people. And I've heard Tanisha be on the phone with the appellants for an hour. So I think, the board office, we really do try to be ambassadors to our appellants, especially those that are pro se, and really try to help as much as legally we can through the process.
Yeah.
Dr. Brooks, I'm curious if I may, would what you're asking about, would that be appropriate for JKA? Maybe hearing information about, because I don't remember if there is a compliance report attached to JKA or not.
There is.
So in that compliance report, would it be appropriate to highlight information on students perhaps engaged in the appeal process, or would that need to be specific to this particular policy? Because I'm just thinking, as we were discussing earlier, Dr. Brooks, a way to streamline information that we need, but also ensure that it comes to us. So I'm just curious about that. And I know that Chief Sivan unmuted a couple of times, but I think he's parenting.
My apologies.
No, please do not apologize.
I was going to just respond to your question. As far as the appeals information, the board office is kind of the holder of that information on the data number of appeals.
You mentioned a compliance report. What were you referencing?
The policy BLA, BLC, BLB compliance report.
Okay.
But Chief Sivan, did you have something to?
No, I was just gonna, when we were asking about the types of appeals, I wanted to flag that we've clarified for instance, in the JBB process, that those appeals ultimately could come to the board. So that's another type of appeal that could ultimately come to the board.
Great. Yep, and I guess Christian, and maybe it's just a conversation with the folks in the office with Tanisha, if like anecdotally we know just kind of student experience, it's really great to hear that there's real human touch to sort of helping people navigate that process. And I just wanted to know for just my own curiosities to make sure that it's an easy process for students and their families.
And I would add too, that's also the vast majority of our appeals are BLA. Well, we get very few BLB and BLC. So that might be a reason why we haven't heard much feedback. They're pretty, and you'll see in the data, they're a pretty small number of the overall number of appeals.
Great. Any other questions from Commissioner Hahn, Commissioner McFadden? Great. So if there are no more questions, I would like to conclude.
Mr. Brooks?
Yes.
Sorry, we had a sign up for public comment.
Oh, we did. I'm so sorry.
Is Mr. Mr. Gaber? Yes.
Hi, Corey. I was about to shut you down. I'm sorry.
Thanks for looking out for me, Christian.
No worries.
Should I get started, or do you need to say anything else?
No, please.
Okay.
But before, I love the cat in the box. The cat in the box is the best screensaver ever. So,
it's much better than my face. I'm happy to put that back on. Follow my cats on Instagram at baby__Capone if you want more cat content. Okay, so that's a real account, by the way. Okay. Hello again, Corey Gaber. Thanks for giving me a chance to speak to y'all. I wanted to hit on a couple general points and a couple specific policy points. For the general points, I actually wanted to echo something that Commissioner James Hassan raised maybe even 2 years ago at a board meeting. I can't recall which one, discussing what stakeholder feedback should look like in district presentations. As one of the stakeholder groups that is sometimes consulted at BTU or BMOR, you see your name on this list in a slide. And I've had the experience of sometimes having our name on the slide where, city schools did deep, really thorough and thoughtful engagement with us. Sometimes we've seen our name on a slide where we've actually had no engagement whatsoever. Sometimes there's been engagement where maybe there's future outreach plan, but the engagement hasn't occurred yet, or maybe there's engagement and we were 100% on board with policy changes, or maybe we vehemently disagreed with the policy changes. And I think if y'all were able to create some sort of systemic, like color-coded system to identify what type of outreach occurred for each of the various groups, it'd be really helpful for the commissioners to know, like whose voices are reflected in this policy and whose voices are not reflected in this policy. And however y'all, decide to do that, great. But I think that sort of more differentiated level information will be super useful for understanding the policy and whose voices are a part of it and whose voices aren't. So I wanted to reiterate that wonderful suggestion I heard a while ago, but I don't think I've seen implemented yet. Second general point is I've seen policies where there have been changes made, and you get in the board docs, you get the most recent version, and obviously you can always access the old version of a policy as well. And then you'll see the PowerPoint presentation that will summarize some of the different changes that were made. But what I haven't seen that I think would be really useful, and I've seen at the state board level a few times, is when there's policy changes to actually have a red ink marked up version of the policy, so you can see the specific language, what was erased, what was added in its place, what was changed. And again, I just think that would be really informative and useful for yourselves and also for the public in trying to understand exactly what changes are made as they're being made. So those are two general points. And then two specific points. I originally came here because I had some alarmed members reach out to me saying, what's going on with this new KDD media relations policy? They're trying to put a gag order on us. And so I said, okay, let me look into what you're asking. And I reached out to Andre Riley, and we had a really great conversation last week. And so I do not believe the members' responses accurately depicting the intentions of Andre Riley and the district in this policy. But I did want to bring up a couple specific pieces of language that I think are worthy of looking deeper at. One is in KDD, there's a quote that says employees of city schools may not issue news responses to news media members without approval of the CEO/designee. And then in KDD-RA, it says at one point, if an employee, school, or office receives a media request by a news media member about district news, they are required to refer the journalist to the communications office for assistance. And then this is me now speaking rather than personally speaking in response to that. And I think that's sort of what gave people that impression. And so what I would push for, because I think there's a lot of good intent there, which is, one, we don't want people claiming that they're speaking on behalf of city schools when they're not speaking on behalf of city schools. They're speaking on behalf of themselves. And two, I want our members to get that expertise and feedback from Andre and his team because, personally, I've had multiple interactions with the media where I feel like I've been misrepresented or I've been mislabeled in terms of my position. And I think folks need to understand from experts, like, how to handle that situation thoughtfully. And I think city schools can offer a lot of advice for employees on that. What I wouldn't want is this sense that anytime I am contacted by the news, I cannot even share my own personal opinion that I've clearly stated is not representative of all of city schools on the matter unless I get approval from the CEO. I think, that starts to get into some touchy territory. And so places where they're saying that we are required, there could be instead language like strongly encourage, or instead of, we can look at the specific language in a couple places, and I don't have all the ideas. And I know Andre's already making changes based on our conversation, but I also wanted to flag that for y'all so that it's really getting at the true intent of the policy. And we are not restricting people's First Amendment rights as long as they are getting coaching and they're clear on exactly how to present themselves. And the other thing we talked about is getting some documents that lay out specific scenarios so they can understand, okay, this is a scenario where if I answered like this, I actually am in violation of the policy and rightfully so, versus if I said this like this, clearly, yeah.
Sorry, 3 minutes of on I think folks are trying to flag you.
Am I out?
Yes.
Okay, can I get like 20 seconds to just say one last thing?
If you also, you should, if you haven't put it in writing as well, if you put it in writing, make sure that we can send it to us. Because I was like, I don't think you can hear us talking.
Sorry about that. Just real quick, the last thing I just want to flag for y'all, in the city schools device use and care guidance, talking about, the laptops that have been lent out, what happens if they get lost, if they get stolen, when they need to be returned. There's some stuff that I found alarming, talking about police reports must be filed with the Baltimore City Police Department. in certain cases, not just when there's theft, but when something is missing, and that city schools will not utilize their tracking software until a police report has been filed. I'm just generally concerned about increasing our families and students' interactions with the Baltimore City Police Department in any manner, even when there is foul play, given their distinguished history in Baltimore City. That's it.
Great. Thank you so much for that, Corey. Please also send us an email or send it over to Christian so he can get that to us. I was not aware of that last piece, and I just need to go back to policy to make sure that I understood what that really meant for us. But yeah, so Christian, are there any other things? I don't want to miss anything else.
No.
Okay. So with that being said, thank you so much again for coming to this meeting, Corey representing the BTU. Also, I just want to say it's now 5:16, and I would like to conclude this meeting for October the 20th. Our next policy meeting will be, it is November the, Christian, what is the exact date?
November 17th. I was going to flag Commissioner McFadden has his hand up too, if you didn't see that.
No, I did not see that. Okay, because I'm reading a note.
It's just really quick, Dr. Brooks. I just heard several references to Dr. James, and I wanted to make sure that we made the correct, what do you prefer to be called? Because we are going back and forth from James to James Hassan to Hassan to, and I just want to make sure that moving forward, we are correct.
You know, just about anything that doesn't have to get blotted out on the media is fine with me. But to that
you
end,
always say that, and I want to clarify it now. So can we make just a clear clarification?
To clarify, I have all respect for my previous relationship and the names that came with that, but I am going back to my maiden name, so I am Commissioner James.
I just wanted to be clear. You know, I think names are important in the way that we work together. I think that's important. So I just wanted to make.
I appreciate that. And yes, I don't want to do any disrespect to the person. And the way I've always done my name is how you met me. You're welcome to call me. But for clarity, I am going back to Dr. James as I move forward in my life. So thank you. Thank you.
And so with that said, our next meeting is November the 17th. Also, please remember to sign up in advance with our board office the Thursday, beginning at 9 a.m. on the Thursday before the meeting until 5 p.m. on Monday before the end of the meeting. And you can also contact the board office at 443-984-2000. And thank you so much, and we look forward to being in community again. See you all later.
Thank you. Good evening.